Reverend Jones, are you going to be able to, I'll get to you in a minute, Eric, because I have a question for you. You're going to be able to tell the people that come to you, if this is signed into law, that it is a fair criminal justice system, sir?
It's a great start.
It is? Okay.
General Benjamin O. Davis of the Tuskegee Airmen once quoted that, you know, it's not what I feel about my country, but what my country feels about me. And when you're poor, the one thing you feel is that my country does not care about me. My country does not love me. And I make that assessment by the way my state treats me, my county, my city, those who we elected to represent us. That's something that we miss. Self-esteem issues that we filter down to people. You know, we cry patriotism. Does patriotism only apply if you have money? Why should poverty be a bar to justice? It shouldn't be.
Eric, one of the things in this bill, my understanding, correct me if I'm wrong, Nick, it would take the rate for a private attorney who took some of these cases from $40 to $70. If it goes to $70, would you take any?
That's not part of this bill.
It isn't?
Yeah, no.
Okay.
It doesn't change the rate for private bar attorneys.
Thanks for the correction. But
with respect to, I wanted to comment with respect to the dean appointments. And kind of, we heard some of the numbers, but let me talk to you for a second about how this works in practice. First of all, what we're doing is we would be distilling 72 separate evaluations into one, and one that's already doing
a uniform system instead of patchwork, 72 different
72 counties.
Excuse me.
And then, so here's how this works. First, as Nick described, somebody will come into the public defender's office, they're evaluated, or the public defenders comes to them if they're in custody, and they'd say yes or no, you're either qualify or you don't. Then that individual goes before the judge, and if they're out of custody, or even sometimes in custody, the judge says, go talk to a lawyer, private lawyer, see what they'll charge, and see if you can find one. And the judges will often require somebody to go to one or more lawyers to find out whether they can afford that lawyer. Okay? Once they've done that, they go back before the judge. And this often takes several court appearances. Every court appearance, there's a judge, there's a bailiff, there's a prosecutor, and nothing's getting done. And this causes a tremendous delay in the system in how long a misdemeanor case or felony case is processed. And meanwhile, in cases where there's a victim, the victim's not having justice either. So this is a failure throughout the system, and one that this would fix, and it fixes it in a way that saves everybody that writes a tax bill money.
Gentlemen, you pretty much indicated that right now our current system is shorthand, justice denied. But Nick, these new rules, the higher income criteria don't kick in until June 19th, 2011.
2011.
So what happens between now and June 19th, 2011? The current broken system lurches forward?
We start prepare. I mean, it's going to take, if this passes as is, it's going to take us some time to rewrite the eligibility criteria, to take issues before our board, to hire the new staff that would handle these cases. So this gives us some breathing room. And you know, hiring attorneys, most of the time we're hiring attorneys right out of law school, which means a May hiring in Wisconsin usually. And so we kind of need that much lead. I mean, I would love to be able to say if this is signed by the governor in March, we can hit the ground running the next month with, but we simply need more breathing room than that.
Okay. Maybe last question for all of you. Let's phrase it this way. If you're busy people, if you were offering advice to the Senate, the Assembly, which still has to pass it, and the governor to sign it into law, you would tell those elected officials, sign it because. John?
Because it's going to save us money and it's going to make the public safer. Those are the two critical elements right there. And obviously our major concern is the public safety, but it's public safety in the context of a fundamentally fair, just system.
Reverend Jones?
It protects poor people who are clothed with the presumption of innocence.
Thank you. Erik?
I would say sign it for the reason that the Indiana Supreme Court said that this was appropriate back in 1853. It should be signed because the defense of the poor in such cases is a duty which will at once be conceded as essential for the accused, to the court, and to the public. And they said that no court could be expected to respect itself to sit and hear a trial where an individual is unrepresented.
Indiana Supreme Court, 1853? Nick, closing comment as the state public defender?
Recently, a critic, I'll go a different way because they said everything that I would agree with. I'm sorry. Recently, a critic of Congress said that one of the problems today is to find good people willing to do the right thing without asking what's in it for me or how can this hurt me. And I would say to sign it without asking those other two questions, especially since we have young men and women in harm's way right now in two different wars that are there not asking, does this hurt me or how can it help me? I would say this is the right thing to do, and you're good people. Sign it without asking how does it help me or how does it hurt me.
Gentlemen, thank you so much for bringing your expertise. I want to thank Milwaukee County District Attorney John Chisholm, Reverend Richard Jones, pastor of Mount Zion Baptist Church in Madison, Erik Guenther, a defense attorney here in Madison, and finally our state public defender, Nick Charkis. It's an important issue. It will be before the Assembly and on the governor's desk soon.
We hope in March, the middle of March.
Gentlemen, it's a very complex issue. Thanks for your expertise.
Thank you.
You got the longest arms. John, you want to bang the gavel? Ending?
You got it.
Ending this, legally speaking. Gentlemen, thanks again.
Thank you.
Thank you.